Welcome once again to Lehto's Law. Here's Steve Lehto.
I'm often complaining about robocallers, and it seems there's no relief in sight. Phones just ring and ring and ring. I understand your warranty is expired. Health insurance exchange. Get a free knee brace. Crazy stuff. And I have gotten a little bit lesser calls lately. Slightly. But I got one yesterday. But I sometimes get dozens a day. And so it does appear they've slowed down a little bit because of what's going on now. But the point is that we know they'll come back with a vengeance once this is all over, because the federal government's not doing anything about it. State governments are pretty much powerless. And so there appears to be just this huge crushing wave of calls that will come over us. And so the question is, can anything ever be done? Well, the good news is that a court awarded a $267 million award against one company that was doing the calls. And they appealed that, and the Court of Appeals let it stand. $267 million award on due process grounds was upheld, and the court is also going to allow the $89 million in attorney fees to stand. We'll talk about that in a second. Last year, a $267 million judgment was entered in Perez versus Rash Curtis and Associates. And that is a federal case going on in California. And that was entered against a defendant debt collection agency. So this is not the same kind of robocalls we're getting from, like India and so on. They could be originating there for all we know. But the point is that this is actually an American company doing this. A jury found them liable for making more than 500,000 robocalls, violating the TCPA, which is a law involving using the telephone incorrectly. The defendant brought a variety of motions requesting the court alter the judgment. And a motion is where you go before the court and make a request and ask the court to do something or make a ruling. So you often hear them say they brought a motion to dismiss, they brought a motion to enforce this, they brought a motion asking for that, they brought a motion to quash. So a motion is when you bring before the court and ask them, this is our motion to ask the court to do such and such. So they brought a variety of motions after asking to have the judgment set aside, modified, reduced, whatever. The judge did grant the defendant's motion to amend the judgment to reflect that the violations were not willful and that the defendant succeeded in disposing of debt collection claims at summary judgment. But those were minor wins because the jury still found that this company made 534,000 robocalls. Turns out that's illegal. Namely, that whopping award and class fees counsel are what really made the headlines, because, again, the jury award is $267 million, and the court approved a third of that to go to the attorneys who did the work and awarded them $89,116,333.33. The defendant argued the class award is statutorily excessive and requested the court to decrease it. The court instead pointed out that the language is clear in the law. The law says that you are liable for making one of these calls $500. And so if you made, I don't know, 534,000 calls that were incorrect, you could do some math on that. I'm a busy man. But 534,000 times $500. And that's what the law says. And they're actually arguing, saying, well, look, we broke the law so badly, we should be punished less. No, you should be punished more. The judge is saying, we're just going to punish you at the exact rate, $500 a call. And there is no binding authority from any court yet saying that they can reinvent, rewrite, or reduce the award based on the fact that you were so excessive about it. The defendant tried to argue that the award is unconstitutional because it is so excessive. Well, $500 a call? Why would a $500 fine be excessive? And you say, well, no, Steve, it's $267 million. No, that's what you get when you break the law 534,000 times. If you break the law more than once, most would say, yes, you should be punished more than once. So if it says every time you do this, you pay this, you should know not to do this 534,000 times. So the court was unmoved and refused to reduce the award. The court noted that the Ninth Circuit, where this is going on, has found that Congress had a rational basis in enacting the TCPA to balance privacy in telecommunications. The law was designed to avoid people getting those stupid robocalls. Second, the court described that TCPA class actions historically generate large amounts because they go after the worst actors, because there's so little enforcement and so little regulation of any actual effect in this field that it's run amok. Everyone knows that. So what the people do who go after this is they pick the worst offenders. They go, oh, this guy made 100 calls. Yeah, this guy made 100 calls. This guy made 500,000 calls. Let's go after him. That makes sense. That's how it should work. And lastly, more than 500,000 calls were made without consent. Thus, $267 million is not so severe and oppressive as to be wholly disproportionate to the offense. So, there is a thing in the Constitution that says the fines can't be excessive. And we've talked about that, Timms versus Indiana. But the fine, don't look at the big number and go, a $267 million fine? That's crazy. No, it's a $500 fine. It's a $500 fine on each instance of 534,000 violations of the law. Makes complete sense. It's just math. This is math a fourth grader could do. And I'm talking about with pencil and paper, not using a calculator. The court disagreed with some cases that were brought before it and argued as examples where district courts had reduced large damage awards. The judge expressed that once you deviate from the statute, the numbers become arbitrary. And by the way, why would you just lower them? Why not raise them? If we can just pick any numbers we want, what if we just pick bigger numbers? The court expressed awareness that some judgments may become uncollectible, and therefore these kinds of cases implore an early settlement. Some icing on the cake included the court denying the defendant's request for a residue statement to allow any unclaimed settlement funds to revert back to it. So apparently, the court's basically saying, look, you're going to put all this money, other than the attorney fees, into a fund and try to distribute it back to the victims. And the question is, what happens if we can't locate all the victims? Well, that might become a thing where they get some of their money back. But like I said, the bigger issue here is that there's a law that says you cannot use these robocallers, auto dialers, whatever we're going to call them. You can't use them in this manner. And each and every time you do that, it's $500. So you break the law 500,000 times. It's not that difficult to figure out. This is just, it's straight math. Now, some people are going to say, Steve, understand what you're saying here. And by the way, this is from the National Law Review. Josh passed this along to me. Thank you for both of them. But some people are going to say, wait, Steve, an $89 million award in attorney fees. $89 million. Is that fair? Does that make sense? Yes, it does. And I'm not saying it because I'm an attorney. You have to realize this case went to a jury trial. It says a jury found it liable for the 500,000 phone calls. So it went to a jury trial, which means that there was a full-blown trial, all the discovery, all the lawsuit, all the litigation that led up to this. And it sounds like a lot of work. And you might still say, Steve, but $89 million for the work? Well, some of that is, in effect, a bounty or an award for the lawyers saying, look, we're glad you took this case. You're going to get a little extra. Obviously, if you simply took how many hours they worked and their hourly rate, it wouldn't come out to $89 million. It wouldn't. But the courts have said there's several ways, more than 2 ways, that you can measure attorney fees. And one is what I just told you, which is hours times rate equals fee. And the other one is where they take in other factors. And the other factors often are things like how difficult the case is and whether the attorneys bore risk along the way. And it's not uncommon in a case like this where the attorneys will actually tell the plaintiffs, you guys sign up, you guys cooperate, we'll put up the money for the litigation, all of the costs, we'll front the costs. And you might say, Steve, how much could that possibly be? Oh, I don't know, tens of thousands of dollars, hundreds of thousands of dollars. I've seen a lawsuit before that went to trial, and it wasn't this big, where there was literally $100,000 in costs that was fronted by an attorney. And the attorney put the money up, hoping he'd get the money out at the other end. But if it's a contingency, which means that he doesn't get paid if he doesn't win, he puts the $100,000 up and they lose. Guess who's out the $100,000? Now, some states have got rules that say that theoretically you're supposed to go back to your client and go, you got to pay me back the $100,000. Doesn't happen. And usually clients don't have it. More likely is the attorneys here were risking their time and their money and had to put all of that up in the hopes that they would win. They won, they get $89 million. They lose, they'd get nothing, and they'd be out whatever money they put into it, and they'd be out the time they put into it. So if you think about it in that scheme of it, that the whole spectrum, they got some cases that win, some cases that lose. And it is not inappropriate to say the winners have got to pay for the losers, because if they didn't, no one would take these cases. And there is case law on this. And the courts have ruled repeatedly that remedial statutes, the word remedy is at the root of the word remedial, and remedial statutes are passed by the legislature in attempt to remedy something that's wrong in our society. So something that's wrong in our society is there's idiots who make 500,000 phone calls that they're not allowed to make. How do we get that to stop? Well, we pass a law against it, but nobody's enforcing it. So what we do is we give a civil remedy where someone who's a victim of this can file a lawsuit and get $500 a phone call for every phone call they got. And they go to an attorney and say, hey, I want to chase this down. And the attorney goes, wait, these people made 500,000 phone calls? That might be worth pursuing. And so they file the action on behalf of all the people in a class action. And when it shakes out at the end, the attorneys have spent countless hours doing the work, put in a ton of their own money doing the work, and at the very, very end, they get paid because they won. And so you might say, Steve, but most of these class actions, you get a coupon good for $1.98 off your next car wash. Well, no, in this case, it looks like these people are going to get $500 back, because that's what they're saying here. It's $500 a call. So whether they get the full $500 back, I don't know. Whether enough people will take the money to get their money back, I don't know. But the point is that they're talking cash here. Cash. So cash is king. Cash is good. So again, National Law Review put the article up. Josh sent it to me. Thank you very much. No constitutional relief is given because the court refuses to reduce the $267 million award on due process grounds. And they award also the $89 million in attorney fees, and they approve that as well. So there you go. Questions, comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Setting a voice recognition password for my phone, and a nearby dog barked and ran away. Now I'm still looking for the dog to unlock my phone.